When a petition for probate or an application for probate is going to be filed, one of the required forms is PC 565. That's a testimony to identify the heirs. This form is the form that identifies how everyone is related to the decedent, essentially a description of the family tree, where the center point is the person that died and how everyone is related to that individual. PC 565, the scale form, testimony to identify heirs, is completed and attached with the petition for probate or application for probate, and it's generally signed and completed by the person that's the petitioner or the applicant in the other document. But it's not a requirement. What that means is that one person could sign the petition and another could fill out the testimony. The form itself requires you to identify the county in which the probate is being commenced, as well as the case number. The next section identifies the name of the estate. This will be consistent with what is listed in the application for probate or in the petition for probate. The next section identifies who the person is that's completing this form, as well as the address and how they're related. It could be a friend, family member, and so on. In addition to some of the pertinent information regarding death. This is really repetitive because the same requested information is included in the petition and the application for probate. The next section is important to understand. Michigan has a 120-hour rule, which means that if somebody fails to survive the decedent by 120 hours, which is 5 days, they are presumed to have predeceased each other. It's really an important consideration here. And the idea here is that, for example, if a person dies with a spouse and they die within a few days of each other within the 120-hour rule, then they are not heirs of that person's estate. They're both considered to have predeceased each other. For more explanation about the 120-hour rule, call my office. I'm happy to explain. It can get a little complicated and confusing when somebody has died within that 120 hours. The next section is an identification. Really, if you imagine a family tree, we start with spouse, if there was a surviving spouse, and then we go to children. Spouse and children are the first thing that we identify. In addition, there's a place here to identify if any of the children are no longer heirs to adoption out, meaning they've been adopted out. And if you are not a child of the surviving spouse, because Michigan's intestacy statute, the statute that governs when somebody dies without a will, differentiates between certain rights for what their allocation is based on whether they are a child of the surviving spouse or not. So that's why the form requires an explanation here. Now, with each part of this form, you'll see that there's like a hard line afterwards, and it says answer the next question only if a certain other question was completed. So first we're looking for spouse and children. The next section says if there are children listed above, did any of them predecease, die before the decedent? And if they did, who are their surviving lineage? And we're talking about lineal ascendants going down. So for example, if there's a child that predeceased, we're not looking for their spouse, we're looking for the grandchildren of the decedent. And again, the same provision holds if those people are no longer heirs because of adoption out. Again, the next section only gets completed if there is no surviving spouse and no surviving children. Then we go up, lineal ascendants, parent or parents. On the back side of the form, we continue down this family tree description. And it says at the beginning, if the decedent did not die with a spouse, descendants, or parents, then we look to surviving brothers or sisters. And if either of those have died, for example, are there any nieces or nephew of the decedent? So we're continuing to filter out this family tree. And at each level, we can stop once we have identified heirs that are identified within that particular space. And that's why it always asks only to complete the section if the earlier section doesn't need to be filled out or is incomplete. The next section says there's no spouse, no descendants, no parent, brother, sisters, children. Then we look grandparents, and then we go on from there to help fill out the family tree. We want to know if there are any heirs that are under legal incapacity, guardianship, conservatorship, children who are represented by parents, and then, of course, that 120-hour rule we spoke of earlier. Did somebody predecease with or die within the 120 hours of which they would be deemed to be predeceased? In addition, there's a section here to identify if anyone didn't survive by 120 hours, who is their representative and their relation to the person. The next section identifies whether there's a will or no will. Testate with a will, intestate, no will. This form is used regardless of whether a will exists, because under Michigan's law, parties are entitled to notice what we call the heirs at law, as well as the devisees that are described in the will. So this form helps identify who is entitled to notice when there's no will or if there is a will. The only way you can get an order that determines somebody to be an heir of the decedent is with the completion of this testimony and a request in a formal proceeding, a petition, to ask the court to make a determination of heirship. This can be really important when somebody is not on a birth certificate or born out of wedlock. You may want to get a court order after death that determines the child to be a child of the decedent. This is part of that larger process. This form is needed to get that order determining heirs. The next section is the signature line of the person signing it, as well as the notarization. It is a document that's signed under the penalties of perjury, and then if there's an attorney, the attorney signs that spot. Again, this larger picture of the testimony to identify heirs is really a document that's used with a petition for probate and an application for probate. I've done other videos on how to complete those forms, but again, if you want an attorney to assist you or guide you through this process, which can often be very confusing for people, call us at 877-YOUR-FIRM or visit us at theprobatepro.com. We're happy to guide you through the process, answer questions that you may have, or if you have some thoughts on other videos that you'd love for us to do explanations on. 877-YOUR-FIRM, theprobatepro.com.